Miss Vance, are you quite certain you're prepared to represent yourself in a case of this complexity? This isn't a homeowners association dispute, you know, Judge Alistair Harrington boomed, his voice dripping with condescension as he peered down from his elevated bench, a smirk playing on his lips. Eleanor Vance, 55, dressed in a meticulously neat but unassuming charcoal grey suit, her silver-streaked dark hair pulled back in a simple chignon, adjusted her understated glasses. "I am, Your Honor," she replied, her voice quiet, yet carrying a surprising resonance in the cavernous courtroom. The opposing counsel, the notorious Bartholomew Sterling, and his phalanx of sharp-suited associates exchanged openly contemptuous glances. The judge leaned back, clearly anticipating a morning of easy sport, a quick dismissal. He had no idea he was about to confront a lifetime of meticulous preparation, a mind like a steel trap, and a legal acumen that would leave him and everyone else present utterly stunned. If you believe true brilliance often shuns the spotlight, only to emerge when justice demands type quiet power below. Eleanor Vance was the kind of woman who could easily be overlooked in a crowd, and she preferred it that way. Her professional life had been spent in the quiet, research-intensive backrooms of a respected, though not flashy, boutique law firm specializing in historical preservation and complex land use law. For 30 years, she was the firm's senior researcher, the one who delved into dusty archives, deciphered centuries-old legal script and built the unshakable factual foundations upon which her firm's partners won their cases. Her name rarely appeared on briefs, her voice seldom heard in court, but her intellect was the bedrock of their success. She found solace in order, in the precise logic of law, in the unearthing of truth from tangled historical records. Her personal life was equally understated. She lived in a small book-filled cottage inherited from her aunt, tended a meticulous herb garden, and found companionship in classic literature. But beneath the quiet exterior lay a formidable intellect and an unyielding sense of justice. That sense of justice had been profoundly violated by Coastal Horizons, Inc., a rapacious development corporation known for its aggressive tactics and deep pockets. They had, through a series of legally dubious maneuvers, and what Eleanor strongly suspected was undue influence on local zoning officials, acquired the small, historically significant coastal property that had belonged to her late Aunt Matilda, a fiercely independent woman who had instilled in Eleanor a love for history and a deep respect for the land. Aunt Matilda had fought Coastal Horizons for years, her resources dwindling, her health failing under the stress, until her death 6 months prior. The corporation, assuming the fight was over, quickly moved to finalize their acquisition. They hadn't counted on Eleanor. Unable to afford the kind of legal firepower needed to battle Sterling and Croft, Coastal Horizons' infamous legal team, Eleanor made a quiet decision. She would represent her aunt's estate herself. She wasn't a barred trial attorney, but her encyclopedic knowledge of property law, combined with a specific state provision for pro se representation in estate, matters with judicial approval, gave her an opening. Judge Alistair Harrington, presiding, was a figure of judicial legend, mostly for his intimidating courtroom presence, his withering sarcasm, and his well-known impatience with anything less than polished, aggressive advocacy from established members of the bar. He viewed pro se litigants with a mixture of pity and contempt, often seeing them as time-wasters cluttering his docket. He'd granted Eleanor's petition to represent the estate with a dismissive wave, anticipating a swift and amusing spectacle. "Very well, Miss Vance," Judge Harrington began, his tone heavy with theatrical weariness, deliberately softening the V in her name to make it sound almost like Vance. "You may proceed with your opening statement, and do try to be succinct. Mr. Sterling," he nodded towards the impeccably dressed lead counsel for Coastal Horizons, "operates on a rather expensive clock." The courtroom, filled with Sterling's junior partners, opposing counsel from other cases waiting their turn, and a handful of legal reporters anticipating an easy story of corporate dominance, rippled with barely suppressed chuckles. Bartholomew Sterling himself, a man whose courtroom persona was a carefully cultivated blend of silver-tongued charm and brutal cross-examination, allowed a patronizing smile to play on his lips. He leaned back, arms crossed, ready for the show. Eleanor walked to the plaintiff's lectern, her movements precise and unhurried. She didn't carry an overflowing briefcase, just a single, surprisingly slim, meticulously tabbed leather-bound binder and a small encrypted flash drive. She adjusted the microphone slightly, took a calm breath and met the judge's gaze directly, her own expression unreadable behind her glasses. "Your Honor, Mr. Sterling, members of the court," she began. Her voice, though quiet, was perfectly modulated, each word enunciated with crystalline clarity. It cut through the low hum of the courtroom, commanding an unexpected degree of attention. "This matter concerns the rightful title and ownership of the parcel of land designated as Lot 47B, Coastal Registry, commonly known as Seaview Point. It is the position of the estate of Matilda Vance, whom I represent, that this property was unlawfully and fraudulently conveyed to the defendant, Coastal Horizons Incorporated. The foundation of our claim rests upon an unbroken chain of title originating with the 1872 State Coastal Homestead Grant Act, specifically Section 3, subsection A, which guarantees indefeasible access and riparian rights to original grantees and their direct heirs, rights which were further protected and defined under the Tidewater Reclamation and Preservation Act of 1903, and subsequently reaffirmed by consistent county zoning ordinances and multiple unchallenged title reviews conducted in 1928, 1958, and as recently as 1997. The sheer rapid-fire density of specific legal citations caused an immediate hush. Bartholomew Sterling's smile vanished, replaced by a flicker of surprise. His lead associate began to tap furiously on a laptop. Judge Harrington, who had been about to interrupt with a sarcastic remark, paused, one eyebrow slightly raised. He still looked skeptical, but a new element of caution entered his expression. "Ms. Vance," he said, his tone a fraction less dismissive, "that's quite a historical mouthful. Coastal Horizons, however, presented this court with a duly recorded quitclaim deed and a subsequent warranty deed, both executed within the last 18 months, apparently extinguishing all prior claims. Are you suggesting these contemporary notarized documents are somehow invalid?" Eleanor adjusted her spectacles minutely. "Not merely suggesting, Your Honor. I intend to prove conclusively that the quitclaim deed upon which Coastal Horizons bases its entire claim was obtained through duress and material misrepresentation made to my aunt during a period of known medical incapacitation, a fact we will substantiate with medical records and expert testimony. Furthermore, the subsequent warranty deed is predicated on an illegally subdivided parcel, created through the fraudulent redrawing of historical survey lines and the deliberate misapplication of a limited access easement. An easement, I will demonstrate, that was never legally perfected under the terms of the 1958 Coastal Preservation Accord, which requires a public hearing and a 2/3 county commission vote for any alteration to primary access routes for properties designated as heritage coastline, such as Seaview Point. She paused, then continued, her voice still quiet but with an undeniable undercurrent of absolute conviction. The precedent for challenging such improperly created easements and subsequent conveyances is well established, Your Honor, notably in Patterson v. State Coastal Commission, 1927, which clearly states that no subsequent zoning overlay or private agreement may serve to extinguish foundational access rights granted under original state land patents without explicit, gazetted public necessity and just compensation. Neither of these conditions was met. Coastal Horizons, in effect, manufactured a landlocked parcel on paper through deceptive cartography and exploited a local zoning variance that was itself improperly granted, all to devalue Seaview Point and coerce its sale. She took out the encrypted flash drive. "As my first exhibit, Your Honor, I would like to present a digitally authenticated, time-stamped recording of a conversation between my late aunt and a Mr. Jonathan Davies, then Vice President of Acquisitions for Coastal Horizons, a conversation in which Mr. Davies explicitly threatens my aunt with ruinous legal fees and the specter of eminent domain seizure based on this fraudulently created easement if she did not agree to sell at a drastically reduced price. This recording was made legally, with my aunt's consent, as she had, by then, come to fear their tactics." A collective gasp went through the courtroom. Bartholomew Sterling shot to his feet. "Objection, Your Honor, this is outrageous. Ambush. We had no prior knowledge of any such recording." Judge Harrington looked at Eleanor, his face a mask of astonishment. "Ms. Vance, is this true? Why was this not disclosed in pre-trial discovery?" Eleanor met his gaze calmly. "Your Honor, the recording was only recently recovered from my aunt's personal effects by the estate. It was immediately submitted to a certified forensic audio lab for authentication. Their notarized report, confirming its integrity and the voices, was delivered to my office late yesterday evening. I had my assistant hand-deliver a copy of both the recording and the report to Mr. Sterling's office first thing this morning approximately." She glanced at a small, elegant watch. 2 hours before court convened. "I have the signed receipt of delivery here." She produced a slip of paper. Sterling looked like he'd been poleaxed. His associates were now in a state of visible panic. The judge, after a moment of stunned silence, his earlier condescension completely gone, simply said, "Proceed, Miss Vance. The court is listening." For the rest of that day and the next, Eleanor Vance didn't just present a case, she conducted a symphony of legal demolition. She cross-referenced colonial-era land patents with satellite GPS data. She brought in a nonagenarian former county surveyor who, with devastating clarity, testified to the original boundary markers of Seaview Point and how they had been creatively reinterpreted in recent decades. She presented internal Coastal Horizons memos obtained through a series of pre-trial subpoenas, so cleverly worded that Sterling's team had apparently not grasped their full implications, revealing their deliberate strategy to isolate and acquire Seaview Point. Her cross-examination of Coastal Horizons' expert witnesses was a masterpiece of polite evisceration. She never raised her voice, never resorted to ad hominem attacks, but with quiet, precise questions, she exposed the flaws in their testimony, the inconsistencies in their reports, until they were left stammering and contradicting themselves. Bartholomew Sterling, accustomed to dominating courtrooms, found himself consistently outmaneuvered, his objections often anticipated and defused by Eleanor's encyclopedic knowledge of both the facts and the relevant law. Judge Harrington, initially a hostile audience, became an increasingly captivated one. He stopped interrupting, his sarcastic interjections replaced by keen, focused questions directed at clarifying intricate points Eleanor raised. He started referring to her as counsel, a subtle but significant shift. The courtroom reporters found themselves struggling to keep up with the sheer volume of perfectly cited case law and historical statutes Eleanor effortlessly produced. The legend of the quiet lioness began to form in the courthouse corridors. The breaking point came on the morning of the third day. Eleanor was presenting a complex forensic analysis of digital alterations made to county zoning maps, showing a clear pattern of manipulation that directly benefited Coastal Horizons. Bartholomew Sterling, seeing his multi-million-dollar defense crumbling before his eyes, under the weight of irrefutable, meticulously presented evidence from a woman he'd dismissed as a harmless eccentric, finally cracked. During a brief recess, he approached Eleanor, his usual swagger gone, replaced by a look of grudging, almost fearful respect. "Miss Vance," he said, his voice low, perhaps we could discuss a potential resolution. My clients are prepared to be reasonable." Eleanor looked at him, her expression calm. "Reasonable, Mr. Sterling? Or finally prepared to be just?" Later that morning, a visibly shaken Bartholomew Sterling stood before Judge Harrington. "Your Honor," he announced, his voice hoarse, "Coastal Horizons, Inc. wishes to concede the plaintiff's claim regarding title to Lot 47B. Furthermore, my client offers a full and immediate settlement to the estate of Matilda Vance, covering all damages, distress, and acknowledging the foundational historical significance of the property, as outlined by Ms. Vance. The terms will be finalized in chambers and submitted for the court's approval." The courtroom erupted in stunned whispers. This wasn't just a settlement, it was a complete capitulation. Judge Harrington, looking at Eleanor with an expression that bordered on awe, banged his gavel for order. "This court accepts the concession and the proposed settlement framework. We will adjourn to chambers to finalize the details." He then looked directly at Eleanor Vance. "Miss Vance," he said, and his voice, usually so booming and arrogant, was now quiet, filled with a respect that was palpable. "Before we adjourn, I feel compelled to state for the record that in my many years on this bench, I have encountered countless advocates, many of them celebrated for their skill. But I can say, without reservation, that I have never witnessed a more brilliant, more thoroughly prepared, or more devastatingly effective presentation of a complex case by any counsel, let alone one representing themselves pro se. You, madam, have not only vindicated your aunt's legacy, but you have delivered a masterclass in legal strategy and intellectual rigor that has left this entire court profoundly impressed and, frankly, humbled. We all underestimated you. That will not happen again." Eleanor Vance simply inclined her head slightly. "Thank you, Your Honor. My aunt believed in the truth. I merely endeavored to present it clearly." She gathered her slim, perfectly organized binder, the quiet architect of an extraordinary victory, and prepared to walk out of the courtroom, leaving behind a legend that would be told and retold in legal circles for years to come. The story of the quiet woman, the unexpected legal genius, who reminded everyone that the most powerful intellects often make the least noise until the moment comes to speak for justice. Subscribe to this channel if you believe that true brilliance knows no stereotype, and that quiet dedication can indeed move mountains and humble giants.